in the financial services industry for broker-dealers and investment advisors and also corporate finance transactions. A lot of my clients are foreign-based or foreign-affiliated, although they include domestic entities as well. So some of the principles we're talking about today could be even more surprising to a foreign bank, to a broker-dealer based in Europe or Canada or elsewhere, even though they can equally be surprising to a domestic audience. So after I speak, Michael Bernstein, who's at my far left, will be our next speaker, and he's the head of our national bankruptcy and insolvency practice. And he's based in Washington and has tremendous on-the-ground experience in dealing with the bankruptcy courts and dealing with the negotiations that arise from disputes such as this. Then after Michael, Stuart Aaron, who's immediately to my left, will be speaking. Stuart is the head of our New York office, recently assumed that position. He's also the president of the New York County Lawyers Association. He's a securities litigator with tremendous experience in the financial services area, class action defense, and he's been taking the lead on a number of cases in the fraudulent conveyance area on behalf of our financial institution clients. So, most of you are familiar with the basic concept of fraudulent conveyances, that they're really designed to protect a company and its creditors from transactions that might cause harm where insufficient value is being provided in connection with the transaction. So value is being extracted, perhaps by the shareholders who are actually tendering their shares and others, but the creditors down the road end up with having as an obligation obligations that are reduced in value because the company didn't receive adequate consideration or anything of reasonable value in return. And anyone who benefited in that manner in the transaction, in that artificial manner, could be potentially liable for the fraudulent transfer. So an LBO transactions are really prime targets for fraudulent conveyance claims because of the allocation of benefits, where some end up doing extremely well, and then when the company is found to be insolvent and eventually goes into bankruptcy, everyone is trying to find ways of reallocating the benefits that have been received over a period of time. These claims are obviously very difficult and expensive to litigate, and so settlements are possible. Some of the bigger cases that we're seeing now are of such a scope, and there's so many participants involved and so many claims to be potentially allocated and reallocated that it makes settlement potentially very difficult. Most of you are also familiar with the leverage buyout concept, where it's really the assets of the target company which are being used to finance an acquisition and a buyout, where the actual equity contribution by the sponsor of the LBO is relatively modest in relation to the overall capitalization being employed in relation to the LBO. LBOs, if I go back as far back to the 1980s and the Drexel Burnham days, they were a remarkable innovation because they really changed the market for corporate control in the United States, so that people with good ideas and with a plan for the business and who were able to perhaps revolutionize the company in some ways were able to participate in that marketplace and affect transactions that were impossible in the past. So they are LBOs, and there's a tremendous amount of financial literature associated with this, have, over time created tremendous value. But during periods when the credit markets have been roiled and a financial crisis has occurred and leverage is your enemy. Many large-scale LBOs over the last few years have failed, and then these claims naturally come forward. So it's definitely kind of a mixed bag on the history of LBO since immediately before the financial crisis and through it, and it's going to create a lot of case law in this area. In fraudulent conveyance litigation, when the LBO fails, the parties they initiate litigation really with two primary purposes. The first is to really set aside the liens that have been granted to secured creditors in an effort to secure more value for the unsecured creditors again on theories that we'll go into in more detail, but on the basis again that insufficient value has been conveyed and the transaction is viewed as a whole. In addition, in multi-step transactions involving a tender offer followed by a merger, public shareholders are also susceptible to having their proceeds recovered in these claims. So normally, the potential for fraudulent conveyance liability arises when there's an allegation that the debtor failed to receive adequate consideration for the transfer, and the debtor at the time of or as a result of the transfer was balance sheet insolvent, equitably insolvent, or left with unreasonably small capital. You can see that those tests are susceptible to a lot of interpretation, and we can talk about that. It's not, obviously, opinions are given at the time regarding fairness of transactions. None of the advisors believe at the time of the transaction that insolvency exists or is imminent. So you'll see that in the actual cases, there's a lot of thinking after the fact to look at what had occurred and how insolvency resulted and how inevitable it was as a result of the transaction. So in a way, on the face of it, when you first encounter claims like this, especially when they involve public shareholders, people who simply were investors or risk arbitrageurs who had no involvement in organizing the transaction, didn't act as advisors, had no inside information, but are still susceptible to these claims. And the legal theory really is that the other parties who were harmed don't have a seat at the table. So the unsecured creditors, in particular, have no way of participating in the LBO process in a way that's meaningful, that would allow their interests to be protected. So that could provide kind of a theoretical justification for reallocating gains that are received by public shareholders, because you have other parties that have been affected that didn't have a seat at the table. The other aspect of it is that you might even have claims brought by bodies like the Pension Benefit Guarantee Corporation, where they may very well, in cases, end up being one of the largest, if not the largest creditor. And if they can demonstrate fraudulent conveyance, they can protect U.S. taxpayers by avoiding the liability they would have to otherwise assume. So fraudulent conveyance law originally developed in response to situations where on the verge of insolvency, people basically secreted their assets or transferred them to others. And we're very far removed from the origins of it, where it was a transfer of assets to friends, relatives, leaving little or no value in their estates for creditors. And it was really, throughout the common law world, the fraudulent conveyance concept has developed along similar lines, even going back as far as 1570 in England. And the relevant phrase has always been, and continues actually to be in the law today, to some degree, to permit an attack on transfers made with the intent to delay, hinder, or defraud creditors. So that's the original purpose, and it's continued in this line to the present in these very large cases. So, obviously during the credit boom, many highly leveraged transactions occurred. People always seem to be immune to realization that leverage can go against them. You see many instances of companies that were highly leveraged as a result of these transactions in the media business, in the housing sector, in many other areas where failures have occurred and inter-creditor disputes have resulted. So, we refer generally to this concept of recovering under fraudulent conveyance principles as a clawback. And clawbacks are kind of a general theme that have really evolved in a number of different areas, where I think in some respects we're going through a period where clawback is a kind of a vogue and one of the themes that we encounter in many areas of law. Increasingly, clawback provisions are included in different types of contracts so that companies can recover benefits that have been given to others in subsequent periods where the activities that were engaged in produce subsequent period losses. So they can be either contractual or they can arise as a matter of law. Obviously, clawbacks have become very prominent, not just in the LBO context, but in Madoff-related litigation as well, where clawbacks are being asserted not only in respect of profits that were earned in fraudulent schemes like Madoff, Ponzi schemes, but also claims for principal amounts as well, to again put everyone on a level playing field so that assets can be reallocated among the various claimants. There are also increasingly Congress is imposing clawback provisions, including most recently in Dodd-Frank, that a provision that requires issuers that are listed on U.S. exchanges to have a clawback policy involving incentive compensation that has been earned when restatements occur. And it isn't just the CFO and CEO that are liable for clawbacks, but across the board. So the general principle here is that clawbacks are becoming a very common theme in the law. Generally, the defendants in a fraudulent transfer litigation aren't just the claims that can be brought against defendants aren't just against the public shareholders and against lenders, but we don't want to miss the fact that there are a tremendous number of claims that are also asserted on fiduciary principles against officers and directors, against the financial advisors that put these deals together as well. So what we're talking about is really going to be one aspect of it, sort of the basic principles that underlie it, and then the ability to recover, efforts to recover funds from public shareholders. So with that, I'll turn the clicker. Well, let me see first if there are any questions in the chat, and I don't see any. So I think this is really just setting the table. So before we entertain questions, I'll turn it over to Michael.
See if I know how to use the clicker that's to the right. This one there. See if I can figure this out. So there's basically two kinds of fraudulent transfer claims: actual fraud and constructive fraud. Actual fraud is the stuff from 1570 in England that Graham was talking about, intent to hinder, delay, or defraud creditors. That's where you see a judgment is about to be entered against you, and so you give all your assets to your mother, and then you say to the creditor, you can get a judgment against me, but I don't have anything. There are relatively fewer LBO cases that involve actual fraud because it's just not common that people enter into LBO transactions with the actual intent to hinder, delay, or defraud creditors. Most LBO transactions are entered into for legitimate purposes of doing corporate acquisitions on a leveraged basis. But you see plaintiffs throwing in actual fraud claims because as long as they're filing the complaint, they might as well. Constructive fraud is where more of the action is. Constructive fraud doesn't require any kind of bad intent or any intent at all. It's a kind of a mechanical test, and it looks at the underlying economics of the transaction. Because in the cases where there are actual fraud allegations, they're hard to prove. And the reason they're hard to prove is because you ordinarily don't have any actual evidence. People don't write emails and memos, at least if they're well advised, saying we're entering this transaction for the purpose of screwing the creditors. Although every once in a while, when you do document discovery, you see internal emails among people who are not careful. And I have seen emails that say things that are unfortunately relatively close to we're entering into this transaction to screw the creditors. But more often than not, you don't see that. And so what the law has developed is what they call badges of fraud. I'll get to in a minute. There's state fraudulent conveyance law and federal fraudulent conveyance law, and this is mostly the same, but there's some differences. And one of the differences, these badges of fraud are actually written into most state laws. And the federal law has sort of, it's not written in there, but they've sort of adopted, the federal courts have adopted it as common law. And what badges of fraud means is facts that are indicia that there may be fraudulent intent. None of them are dispositive, but it's factors that the court can look at in trying to figure out whether there's actually a fraudulent intent. For example, I'm not going to go through all these, they're in the materials, but if you're transferring something to a family member or an insider of the company, that doesn't mean it's fraudulent, of course, intent, but it's a factor you might look at. If the transferor transfers title to an asset but keeps it, actually physically keeps the asset himself, that may look like it's a fraudulent intent. If this transaction was kept a secret, intentionally kept a secret by the transferor, you could look at it and say, well, if they kept it a secret, maybe that means it's a fraudulent intent. And so, of course, any one of these you could say there's legitimate reasons too. You kept it a secret because you don't want the competitive landscape to find that competitors to find out about it. So, but anyway, the courts go through these factors to try to figure out whether there's fraudulent intent because of the difficulty of actually getting somebody to admit that they did a transaction because of fraud. In terms of how it works in practice, the plaintiff tries to prove that some of these factors exist, some of these badges of fraud, and then the burden shifts to the defendant to show that there was no fraud, notwithstanding the existence of the burden. The real action here, and this isn't in the slides, but the real practical action here is whether the plaintiff can get through a motion to dismiss on an actual fraud case. Because what the plaintiff will do is plead in his complaint enough of these badges of fraud, just kind of assert that they exist, and that for a long time was sufficient to get past the motion to dismiss. It doesn't mean the plaintiff's going to win the case, of course, but it means that the case is going to be very expensive to litigate, because once you get past a motion to dismiss, then there's document discovery, and in a lot of these transactions, the big transactions, there's a lot of documents, and it's expensive, and it's a settlement tactic for plaintiffs to file these actions, assert some badges of fraud, try to get past the motion to dismiss, and then try to use the legal expense and the expert witness expense and so forth as a basis for trying to coerce a settlement. Of late, it's become a little harder. There's been some decisions I won't go into that say that you have to do a little bit more than just allege badges of fraud. You actually have to have allegations that look like they have some substance, and we and other people who litigate these cases have had some success recently getting these knocked down on a motion to dismiss because the Supreme Court has changed the law a little bit. With respect to constructive fraud, as I said, there's no intent element. It's a mechanical test, and there's basically two parts to it. One is insolvency, and two is value. So what this means is a transaction is fraudulent if the transferor was insolvent at the time it made the transfer, or became insolvent as a result of the transfer, or didn't become insolvent but was left with insufficient capital to run its business, and transferred the assets for less than reasonably equivalent value. So you have to meet both of these tests. So if you're clearly solvent, if you have $50 in liabilities and $1 billion in assets, you can give away your assets for free, and it's not a fraudulent transfer because you're solvent before and you're solvent after, and you got plenty of money. But if you're insolvent, or the transaction renders you insolvent, and you sell your assets for less than fair value, or you give them away for free, then you're constructively fraud, even if you had no intent to defraud anybody. It's a mechanical test. So this is where most of the LBO fraudulent transfer action is in the constructive fraudulent transfer area, because the acquisition vehicle borrows money from a lender and pledges the assets of the target company that it's buying to secure the acquisition financing. So the buyer gets something. He borrows money and he buys a company, right? And the selling shareholders, of course, get something. They get paid with the acquisition financing, right? They get their company bought. But the fraudulent transfer problem, the core fraudulent transfer problem, is that the target company, the acquired company, is granting a lien on its assets. And often when the acquisition vehicle actually merges afterward with the acquisition vehicle, actually assuming the indebtedness. So the acquired company is granting a lien on its assets and often becoming liable for a debt. And it's arguably not getting anything in exchange for that, right? Because the loan proceeds are going to the selling shareholders. So the company is just getting bought. Before the sale, the company exists, and it's owned by somebody, and it doesn't have a lien on its assets, and it doesn't have the debt. After the transaction, the company is owned by somebody else, and the company now has a lot of debt, and all of its assets are liened up. And sort of looked at from the company's perspective, you could say the company doesn't care who the company is owned by. It's owned by somebody and it has free assets. It's owned by somebody else afterward, and it has all its assets liened up. And so from the perspective of the creditors of the company, that could be a fraudulent transfer. Because the creditors of the company, they had a company with a lot of free value, unencumbered assets before the transaction. Afterward, the company doesn't have assets, and all its assets are liened up. And so that could be a constructive fraudulent transfer, because the company has incurred debt and granted a lien. It's made the company insolvent. Now, maybe it hasn't. That's a fact question. But it's made the company insolvent. And the company did not get reasonably equivalent value in exchange for granting its liens and incurring the acquisition financing. At least that's the theory. Now, we'll get to holes in the theory. But that's the fundamental theory for fraud, avoiding LBOs as a fraudulent transfer. As I said, I'm just going to spend a minute on unreasonably small capital, because most people talk about insolvency in a fraudulent transfer. And when you talk about people kind of colloquially, they talk about it can't be a fraudulent transfer unless you're insolvent or rendered insolvent. And that's, most of the cases are like that, but it ignores this unreasonably small capital part of the statute, which is even if you're solvent before the transaction and solvent after the transaction, if you have unreasonably small capital to operate your business, then it can still be a constructive fraudulent transfer. And people sort of know what balance sheet insolvency is. At least you can get experts to testify about it. Equitable insolvency, which means not paying your debts in the ordinary course as they come due. That's a little fuzzier, but you can still prove it. You can list all your debts and see if you're paying them or not paying them. This unreasonably small capital is even fuzzier. It makes more litigation because what's unreasonably small capital? You have sort of relatively small capital, but how low does your capital have to get before it's unreasonably low? And there's a bunch of factors that courts have gone through, which are in the materials, and I don't think I'll go through all of them because of the time we have. But I'll say this, the most important fact to look at in thinking about unreasonably small capital is how it's industry specific, right? Some businesses are very capital intensive. Other businesses are not as capital intensive. The timing imperatives for certain companies are different. The runway is different for some companies than it is for other companies, and it becomes very industry specific and very company specific in terms of what unreasonably small capital means. In practice, this tends to be in court about a battle of the experts. And so again, is another reason defendants push so hard to get these cases knocked out on motions to dismiss, is otherwise you're in for expert witnesses and expert witness fees and expert witness discovery and trying to explain to a judge who probably is a smart person but also probably has no expertise in your particular industry what reasonable or unreasonable capital is in your particular industry and your particular company. In terms of how this actually works in bankruptcy, so how it actually works in bankruptcy is, so one of these LBO transactions occurs, and then sometime later there's a bankruptcy filing, and the debtor is given the right. The debtor in bankruptcy is given the right under 548 of the Bankruptcy Code to bring a fraudulent transfer action to attack the LBO. They could often they will sue the shareholders who got the proceeds. Sometimes, though, they will sue the lender who has a lien on the assets, the lender who provided the LBO financing, even though the lender didn't do anything wrong, right? The lender made a loan and got collateral. And almost always these are not actual fraud cases. They're cases where the lender loaned $300 million, got a $300 million note, and got the assets as collateral, and nobody's really accusing the lender of wrongdoing. But the company, remember, didn't get value. The selling shareholders got value, and the acquisition vehicle got value. So the debtor is given the right to sue to undo its own transaction. Now, the debtors often don't want to do this. Sometimes they do, but sometimes they're in a conflicted position because they're the same people who did the transaction, and now they're supposed to sue to undo the transaction. Maybe they're supposed to allege that this was a breach of fiduciary duty, but they're the ones who would breach their fiduciary duty, or it was their friends, and the selling shareholders were often the founders of the company, so they often don't want to do this. So this is not in the Bankruptcy Code, but the courts will consider allowing the creditors committee to bring these actions instead. The creditors committee has to go to the court and show that the debtor has a conflict and that there's a plausible cause of action, the plausibility being a kind of a fairly low standard, although sometimes we go in and fight the plausibility when we don't want the committee to be able to bring the action, saying the committee's just going to be wasting everybody's money by bringing this spurious action. But the debtors will sometimes just allow the committee to bring it because they don't want to. If the debtor doesn't allow the committee to bring it, doesn't consent, the debtor kind of looks worse because they're trying to get nobody to bring the action. So the committees can bring the action if the debtor doesn't. Sometimes an individual creditor will try to bring the action itself. Again, that requires court approval. The reach-back period under 548 under the Bankruptcy Code is 2 years. So if the transaction happened 3 years before the bankruptcy, you can't sue under Section 548 to undo it, even if it was a fraudulent transfer. However, there's a remedy here, which is under Section 544 of the Bankruptcy Code. The debtor or the committee, if it gets standing, is allowed to use state law to bring a fraudulent transfer action. Remember, I said there's federal fraudulent transfer law and state fraudulent transfer law. And if the debtor or the committee wants to, it can use state law to bring a fraudulent transfer action because Section 544 of the Bankruptcy Code essentially incorporates state law into the federal law. It's, the words are a little more cryptic than that, but that's the effect of what it does. So the main difference between the state law and the federal law, there's some other differences, but the main difference is the reach-back period is longer. So instead of 2 years, you can go back longer. And that's often just a critical fact, right? If the transaction is clearly fraudulent and it happened 3.5 years ago, under federal law you get nothing, and under state law you have no problem with the statute of limitations in most states. When I say it's longer, it depends on what state, and I'll get to that, but the periods vary. But I think every state, as far as my recollection, every state is between 3 and 6 years. So they're all materially longer than the federal law. There are various defenses to fraudulent transfer, um, uh, some of which are going to be obvious from what I said because they're just contesting the fundamental elements, right? For example, you could argue that you made reasonably equivalent value for the transfer. You could argue that there was no insolvency or unreasonably small capital. But one of the defenses that's not obvious from the elements, an affirmative defense that's been a subject of a lot of litigation lately, and a fair bit of uncertainty, I think, in terms of the way the law is headed, is this Section 546E. 546E is interesting because it's a situation where I think the plain language of the statute and the intent of the statute are a little different. And this is what the courts have been struggling with, is which to go by. What 546E does is it's intended to create a safe harbor, create an exception to the fraudulent transfer law. Not intentional fraudulent transfer, because if it's intentional, there's no defense. But for a constructive fraudulent transfer, create an exception for essentially settlement payments made in securities transactions. Now, the words are a lot broader than that, and the definition goes on for a page. But the basic idea is that if you're selling securities in the markets and you're able to avoid a transaction that happens, a stock sale transaction and so forth, it could have a domino effect. It could have an adverse effect in the capital markets, right? Because of the way securities transactions are cleared on a net basis, right? And if some big transaction is avoided, and it's not going to be one transaction, right? When a sizable company goes insolvent, it's going to be a lot of transactions. It could have a ripple effect in the capital markets. And for that reason, Congress created this exception to the fraudulent transfer laws for essentially settlement payments that go through stockbrokers or go through financial institutions. And there's a lot of language and a lot of definitions here, but that's the fundamental purpose of this transaction. And there are two interesting things that are going on in this area that you should be aware of. One is the applicability of this section to private transactions, and there's been a lot of litigation going on here, because from the purpose of the statute that I just told you about, the exception, it's kind of obvious that what's intended here is public company transactions, right? Transactions where there's a capital markets impact of avoiding a settled transaction. So you would say if Joe and his brother own a bar and grill, and there's an LBO transaction, and Joe and his brother get paid, and the transaction happens through a financial intermediary because they just escrow the stock and escrow the cash payment in a bank, so it's cleared through, quote unquote, cleared through a bank. You would say, well, that's not really what they're talking about here in the statute. That's not going to have any ripple effect in the capital markets. Nobody in the capital markets is even going to know that the transaction happened, unless maybe they happen to be the people who drink at that bar and grill. And so the question is, does this defense, which is an absolute defense, it means the selling shareholders can get their LBO proceeds, and even if the transaction was less than reasonably equivalent value, and even if the company was insolvent, it's a defense. Can that defense happen in a private company transaction? And the case law has gone back and forth here, because again, if you read the words, I won't bore you with all the text in the statute, it's in the slides, but if you read the words, it suggests that it's not limited to public company transactions. If you read the legislative history and you just sort of think about what the intent is, it suggests at least that it is limited to public company transactions, or at least that is one reading of it. And so originally, the very early cases said this is limited to public company transactions. There were not many of those cases. It just sort of doesn't come up that often, right? I mean, most of these cases settle and so forth. Then there were cases that held that, no, you need to read the plain language of the statute, and you need to focus on what the statute says, not what the intent is. This is the Justice Scalia on the Supreme Court approach of just read the statute and follow the statute. That's the job of judges, not to worry about what was intended or how Congress could have written the statute better if it had wanted to. And there were three there were 3 Court of Appeals cases, at least that I'm aware of, that applied this defense to private company transactions. So that there's a transaction where where the company is left insolvent as a result of an LBO. The selling shareholders get paid a lot of money for their shares. The company files bankruptcy. The creditors are looking at a very small recovery because the company was rendered insolvent as a result of the LBO. The selling shareholders are living in Anguilla on the beach, and they have an absolute defense under 546E, even if it were a private company, even though it had no impact on the capital markets, because the court followed the words of the law. Much more recently, the Bar and Grill case actually happened right here in the Southern District of New York. I wasn't making this up. There was a case before Judge Drain involving, I believe it was Judge Drain, involving the Bar and Grill.
In New Rochelle, you can see it off Route 95. McMenamins is where it used to be on the right-hand side. I know Rob Holden's passed it many times. Yeah.
So this is now you get the division of responsibility on our panel. I'm talking about the fraudulent transfer law, and Stuart knows the Bar and Grill.
Right.
The Bar and Grill was sold, and it was a fraudulent transfer, and at least it would have been a fraudulent transfer, and the defendants made the 546E defense, and they cited all this Court of Appeals case law and said it applies to private company transactions. And when you have 3 Court of Appeals cases, it's a pretty good argument, right? And you're before a bankruptcy judge. Now, none of these Court of Appeals cases are in the Second Circuit, so they're in other places, so it's not binding on a New York court. But you would think you have 3 Court of Appeals cases going one way. As far as I know, you have no Court of Appeals cases going the other way, and you have a lower court judge here in New York, but you have a very smart, very thoughtful judge here who's not afraid, who's not timid, and not afraid to call it as he sees it. And he said, look, that's just not what this means. This statute just was not intended to cover bars and grills. The sale of this bar and grill has no impact on the capital markets, and this defense doesn't apply. So it's the answer is there is still a lot of authority for applying this section of the code as a defense in a private company transaction. The Bar and Grill case? I don't believe so. No, I don't believe so. I think, we usually say at the beginning of these panels, we end up litigating over a long time on both sides of these transactions. So I should add that since this is apparently being recorded, that I'm just discussing the law here, and nothing that I'm saying is binding on any client of ours or on us in any future court proceeding. But I think there is a strong argument based on the text of the statute that this does apply to private company transactions. And I think there is a strong argument I think there's a strong argument that Congress is aware of this issue and has been aware of this issue for a while. Indeed, the statute was amended in 2005, and that if Congress wants to apply it to public company transactions only, Congress can amend it, and until then, the Supreme Court has said, and Ron Perrin and other cases, that the lower courts are just supposed to read the statute and apply it. So I think at a minimum, that's worth asserting. The other important issue under 546, the other is how creative people have tried to get around it. Usually, creative creditors committees, because as I said, often the debtors aren't motivated to bring these actions, and so they have transactions. They're looking at undoing an LBO, which is often, by the way, in these cases, because the assets are all rigged up as a result of the LBO transaction, and sometimes as a result of DIP financing as well in the bankruptcy case, the only way to get any value to the unsecured creditors, they're looking at 2 cents in the value, 2 cents on the dollar kind of extortion value if they can't unlock the assets, avoid the lien or get back something from the selling shareholders, and So the committees are highly motivated to bring these actions, and creditors' committees litigate with the debtor's money. So they're not spending their own money to litigate these. So they're really very highly motivated to unlock the value by avoiding these fraudulent transfers. And when they have cases where they can't do anything about the 546E defense. Now, if it's a private company transaction, they can at least argue that it doesn't apply to private companies. But in a public company transaction, which was cleared through a stockbroker or a financial institution, which they almost always are, you kind of say the committee can't do anything. And so the committees and some debtors have gotten creative very, very recently, so recently that I can't really tell you where the law is headed here because it's new and emerging. And what they try to do is they just abandon the cause of action entirely. If they bring the claim, they're going to lose. So what they try to do is they let the 2 years pass, the 2-year federal statute of limitations. They let the time period pass, and then the debtor no longer has a fraudulent transfer action. He probably didn't have one anyway because of this defense, but now he technically doesn't have one because it's let the time pass. And then they say that the individual creditors themselves can bring a state law action. Now, while the debtor has a cause of action under the bankruptcy code, the individual creditors can't bring this action. But once the debtor no longer has a claim, there's an argument, just an argument, but there's an argument that the individual creditors can bring a claim. The individual creditors are not allowed under the law to bring a federal law claim. They have to bring the state law claim. The state law claim does not have the 546E defense in it because it's just not in the state law, at least any state that I'm aware of. And so the creditors can bring the action individually and argue that 546E doesn't apply. And this is sort of obviously an end run around the federal law. And I don't know how this is going to come out because it's really just like something that people just are coming up with now. And but in those cases where you think you have a rock solid 546E defense, maybe you don't. If you have some creative people on the other side. And again, if you sort of back up about 4 steps and look at what's really happening here in most of these cases are negotiations, and most of the time the creditors committee is looking at no recovery, and it's negotiating, and it's threatening the selling shareholders, and maybe it's threatening the banks that finance the LBO. And what it really wants is to pay 15 cents on the dollar to its constituency so that it has delivered some value and it can declare victory. And it goes to the creditor, and the creditors committee goes to the selling shareholders or the banks and says, we're going to sue to avoid this LBO. And people say, well, 546E, so you can't come after the selling shareholders. By the way, you may still be able to go against the lenders because 546E, it's a lot less clear that 546E has any impact on a fraudulent transfer action against the lenders. But the committee goes to shake down the lenders and shake down the selling shareholders, and the selling shareholders say it's 546E, so we have a defense, so go take your 2 cents on the dollar and go home. And this is one of the things. So what does the committee say? So one of the things the committee says is we're going to let the time period pass, and we're going to give this action to individual creditors who, by the way, may be members of the creditors committee, so they may be in on all of this, and they'll sue you. And they have to sue with their own money, by the way, so it's not like the creditors committee where they can sue using OPM, as they say. They're going to have to sue with their own money, but in some cases, some of the unsecured creditors are going to be big enough, right? Maybe they're indenture trustees and they feel like they have a fiduciary duty, or they're instructed by rec lenders and so forth, or supermajority of the bondholders, whatever it is. So you can get individual actions, and the threat of these individual actions, if the case law moves in that direction, the threat of these individual actions is going to allow some recovery for unsecured creditors. That is basically, I think, what you want to know about 546E. In terms of state law, I mentioned some of this already. Most of the state law is the same. Most of the states have adopted the Uniform Fraudulent Transfer Act. A few states have the Uniform Fraudulent Conveyance Act, which is different in respects that can be important, but not at the level that we're talking about here. Every state has some fraudulent transfer law. This means, by the way, that you can bring fraudulent transfer actions in state court even if there's no bankruptcy, right? If a company that's not in bankruptcy transfers its assets for less than reasonably equivalent value and leaves itself insolvent, and it's not in bankruptcy and it's not in receivership and it will never be in bankruptcy or receivership as far as you're concerned, but you're a creditor and you're unhappy about the fact that your credit position just got worse, you can bring a fraudulent transfer action in state court. People think of this as like a bankruptcy concept, and a lot of it happens in bankruptcy court, but you can bring these actions in state court. The most important thing I talked about is the statute of limitations, which is longer in state court. That's why people use state law. There's also in many states the definition of insolvency is different and broader than under the bankruptcy code. So, for example, state law will allow a fraudulent transfer action to be brought based on equitable insolvency. So let's say you're balance sheet solvent, but you don't have money to pay your debts as they come due. You're equitably insolvent because you suffer from illiquidity. Under the bankruptcy code, if you're balance sheet solvent, you can't bring a 548 action. Under state law, you can bring it if you're equitably insolvent. And so there's differences like that. So anybody who's bringing one of these, you have to at least look at state law. And there have been cases where they've succeeded under state law where they would not succeed under federal law. The last thing I want to talk about is something we've called collapsing transactions here, which I think is actually a key point in fraudulent transfer law affecting leverage buyouts. And that is kind of collapsing transactions means, these transactions have different parts, right? Sometimes they're written in one document. Sometimes they're written in 2 or 3 documents. Sometimes they happen at different times. So one transaction happens one time and another transaction happens 6 months or a year later, but they're all contemplated as part of the same business deal. And so, the question is, does the court look at each part of this separately, or does the court look at the whole mess and seeing if there's reasonably equivalent value? I think a typical example is this. Let's say the classic LBO fraudulent transfer case. The company pledged the lender borrowed $1 billion. I'm sorry, the acquisition vehicle borrowed from the lender $1 billion. The $1 billion, all $1 billion of it went to the selling shareholders. The company got nothing. By the way, that's often not the case, right? Often some of the acquisition price is an investment into the company, but for capitalization, and that makes the reasonably equivalent value case more complicated because the company actually did get something. But let's say the worst case, right? The $1 billion all went to the selling shareholders. The company's assets were totally unencumbered before the transaction. Now there's $1 billion lien after the transaction, and it's a classic fraudulent transfer. And you would say, okay, well, what's the defense here? Putting aside 546E, you'd say from the lender's perspective, maybe, what's the defense here? Right? The company got no value in exchange for this transaction. It's a fraudulent transfer. But there's usually other parts to the transaction, right? So then when we're defending these cases, we say, okay, well, what did the company get? What did the target get here? Under the loan part of the transaction, it got nothing. So if you look with blinders on it, nothing but the loan document, maybe it got nothing. But look at the rest of the transaction. What did it get? Because there's usually never a situation where it's just a loan and that's the end of the game. And so maybe it got a line of credit, right? Maybe as a result, in connection with the transaction, the lender also provided a line of credit to the company. After all, if the lender is financing this transaction, it's making $1 billion bet on the success of this company, right? So maybe it provided a line of credit in connection with the transaction so that the company could continue to do business. Maybe in the private equity context, it had access to other relationships that the private equity fund has, right? So the company was gaining relationships with other companies, right? Maybe it has an opportunity. I've seen cases where the company, as a result of being bought out by a PE fund, has the new opportunity to sell product to another company. Sometimes it merges after an LBO transaction, but as a result of the LBO, it merges and it gets scale as a result of that, and a strong merger partner. And anyway, there are other examples I could give, but each of these transactions. So the merger is probably a good example. although the line of credit isn't bad either. These all happen under separate documents, but they may happen at separate times, right? So if you look at the loan transaction alone, you'd say it's a fraudulent transfer. But if you look at the totality of what the company got a capital infusion, which often happens. It got access to future financing. It got access to new business relationships. It got access to new places to sell its business. It got additional scale. It got a merger partner. It may got the advantage of the partner that it has in its new lender. And if you look at all of these things taken as a whole, you collapse them into one transaction, you may have a situation, you may very well have a situation where the company did get reasonably equivalent value. And so a big issue in these cases is whether the court will look at each individual part of the transaction or will collapse it. Interestingly, just depending on how the facts are, sometimes you see the plaintiff trying to collapse the transaction because the facts get worse when you look at the other elements of the transaction, just depending on what the facts are. Sometimes, often, they get better from the perspective of the target because the acquired company actually got value if you can look at the transaction as a whole. I went through all this quickly, and it's a lot of material. It's so I apologize for that, but I wanted to give you at least a high-level overview of all this. And if there are questions, I can take them now, or I can wait, or Stuart can talk, whatever you.
Any questions at this point? There are none online at the moment. Any questions here in the audience? If not, think about your questions, and we'll have a question period after Stuart's part of the presentation where we'll talk about some recent cases.
Oh, sorry. Well,
you should repeat the question for the people on the phone.
So the question, thanks. The question was, what about fraudulent transfer risks with respect to a company that is insolvent or in the zone of insolvency and is doing a debt exchange, so a lot of this comes down to structure. A lot of this comes down to transaction structure because, as you know, debt exchanges can be structured in different ways. If where it's a debt for debt exchange, it's the case law. I'm actually litigating a case that in part involves us now, but in a debt for debt exchange context, the law should be that there is no fraudulent transfer because the company is ordinarily not giving value. It's not transferring assets for less than reasonably equivalent value. Now, but then it becomes fact specific, right? Because if it's granting a lien to secure unsecured debt, then it may be conveying assets for less than reasonably equivalent value. If the debt terms are getting worse from the company's perspective taken as a whole, which ordinarily is not the case, but again, it's very much fact specific, you can make an argument for a fraudulent transfer, although I'll say that as a practical matter, these arguments are difficult to make. Part of the reason for that is that the definition of value in the bankruptcy code includes satisfaction or securing of a pre-existing debt, an antecedent debt. So if you have unsecured debt and you grant a lien to secure that unsecured debt, let's say the situation is there's a maturity date coming up, everybody knows you can't meet the maturity, the lenders don't want to take over the company, so they say we'll give you another 3 years and we'll ratchet down the interest rate and you'll pledge collateral. And so you say, well, you pledged collateral, so you gave some value. Did you get enough in exchange for that? Which would be a fact question. Maybe you did get enough in exchange because you got a deferral of maturity. So that's one reason it would be hard to prove. But another reason it's hard to win those cases is because granting collateral on account of an antecedent debt is is by definition value under the fraudulent transfer laws. You have to be careful, though, because we're sitting here talking about fraudulent transfer as if it were the only way to avoid a transfer, right? And as some of you know, there's preference laws also, and if you grant an unsecured credit or a lien to secure pre-existing unsecured debt, and then you file bankruptcy within 90 days, it is very likely not a fraudulent transfer, but it very likely is, or at least may be, your preference because it's granting collateral on account of a pre-existing debt. So these are tough cases to make under the fraudulent transfer laws.
Okay, so I'll turn it over to Stuart now.
Okay, thank you, Grant and Mike. So what I'm going to talk about are two specific examples where the law that Mike has just discussed have been, these legal principles are being applied, and they're both examples of cases that are currently being litigated in the courts. The first involves Tribune. Tribune, for those of you who have been living underground for many years, is a media conglomerate which owns 23 television stations and 12 newspapers, including the Chicago Tribune and the Los Angeles Times, as well as they own the Chicago Cubs. So what happened was there was this real estate developer named Sam Zell who took control of Tribune in this two-step transaction that's, I apologize for the size of the type, but basically in the first step of the transaction in June of 2007, a newly formed employee stock ownership plan purchased a large number of shares of Tribune common stock. An entity owned by Zell made an initial investment in exchange for some shares, and then Tribune had a cash tender offer to repurchase a certain percentage of the outstanding common stock. Tribune then retired the repurchased shares, and as a result of this step one, shareholders received $4.3 billion for their shares. Then came step two. In December of 2007, Tribune merged with a Delaware corporation wholly owned by the ESOP, and Tribune survived the merger. And upon the completion of the merger, all of the outstanding shares of Tribune's common stock were canceled, and Tribune became wholly owned by the ESOP. And in the step two process, the shareholders received approximately $4 billion for their shares. And I suppose that these two steps of transactions are going to be collapsed, or the unsecured creditors, which when we get to the next slide, and the other creditors who are bringing claims presumably will try to collapse those transactions. So what happens is those transactions end in December of 2007, and then a year later, Tribune files for bankruptcy. And in February of 2010, there's a group of unsecured creditors, namely the official committee of the unsecured creditors, sues for relief under the Fraudulent Conveyance law, claiming that Tribune, as a result of the transactions, did not receive reasonably equivalent value, and that's the concept that Mike just talked about earlier. The committee also argued that Tribune was rendered insolvent by the LBO, or that it was foreseeable that Tribune would be rendered insolvent if the LBO occurred. They asked the Delaware Bankruptcy Court to take away the liens of the lenders and subordinate their claims also at that time. Then in April of 2010, I'm not keeping up with the slides, I apologize. In April of 2010, the Bankruptcy Court appointed an examiner named Kenneth Clay. He evaluated the allegations that the LBO violated the bankruptcy law. He issued a report a few months later where it was concluded that Tribune did not receive reasonably equivalent value, and it was highly likely, that's the words that he used, that Tribune was rendered insolvent and without adequate capital by the second step of the LBO transaction. The examiner wrote in his report that the fiduciaries didn't adequately discharge their duties. He said that he found some evidence of intentional fraud, but he said that the evidence of constructive fraud was much stronger. So what happens thereafter is that Tribune gave its rights to bring suits to the committee, and it obtained permission to file a claim alleging intentional fraud against the shareholders, and that's within that 2-year statute of limitations that Mike had described earlier. The bankruptcy court recently granted the committee's motion to dismiss claims against former named shareholders who received less than $50,000 in proceeds. But what I should mention, and we get to this in a moment, those very shareholders are still part of the defendant class that's been alleged. So anyone that received less than $50,000 still isn't completely in the clear. So the bankruptcy judge stayed the suit pending the completion of the Chapter 11 process. And then the committee did exactly what Mike said. Folks have been doing aggressively to try to get around 546E. They let the statute of limitations lapse and argued that the individual creditors could then bring the claims under state law, trying to get around the 546E safe harbor. And in March 2011, they sought authority from the bankruptcy court to bring those state law fraudulent conveyance actions. The objections were the ones that you would expect to be raised, that only the debtor has the authority to bring the claims, individual creditors cannot, and also that 546E preempts state law, and therefore essentially what the end run around 546E should not be permitted. What the court basically did was punt, because what the court said is basically that sure, you can bring the claims, but what the last bullet on this page points out is that the judge said he was making no finding regarding the standing of the note holders or any creditors to assert the state fraudulent conveyance claims, or whether such claims were preempted or otherwise impacted by Section 546E. So nothing's been decided yet. In terms of the scope of this proceeding, there are approximately 1,700 individual defendants that have been actually named in the lawsuit. And there also are, as I mentioned, class allegations where claims are being made purportedly against a defendant class. And in all, there's about 33,000 to 35,000 investors who are potentially liable for the money they received back in 2007. And in December of 2011, December of last year, the U.S. Judicial Panel on Multi-District Litigation consolidated the 44 fraudulent conveyance suits. So they had actually been filed, most of them, or I think all of them, in state court. They were moved to federal court by the defendants, and then they've all been consolidated before Judge Pauly here in the Southern District of New York, but they have been stayed. In terms of a recent update, in yesterday's docket, the Judge Pauly had asked for various submissions concerning how the case should proceed. He issued just yesterday Master Case Order number 2. He's going to be holding a conference with counsel on July 12th at 11:30, and a couple of things he wants to discuss are a schedule for motions to dismiss, which likely are not likely will be coming under 546E and the grounds I discussed earlier. And the defendants have gotten together and proposed an organizational structure for any of you on the phone or in the room that are wondering. That there's various groups of defendants that have grouped together and appointed proposed leads to basically deal with the court. And there's 5 or 6 or 7 law firms that one can reach out to get information depending on which class. There's financial institution holders, there's mutual funds, there's pension funds, and others that are purported to be represented by, or where what these lawyers would be is basically liaison. So you can deal with them in terms of administrative matters, briefing motions. What they're likely will be consolidated motions to dismiss, and then individual defendants that have unique issues would be able to put in supplemental briefing just to make the points that they want to make. So the second example is Lyondell. Lyondell was a chemical company merged with Basell in July of 2007, creating one of the world's largest polymer, petrochemicals, and fuel companies. Basell had been an international company controlled by Blavatnik. And in May of 2007, Blavatnik acquired 21 million shares of Lyondell stock and said he was looking to acquire all of the stock. And in July of 2007, Basell agreed to purchase Lyondell in an LBO for $48 per share. and the Lyondell shareholders received $12.5 billion. So sure enough, less than 2 years later, in January of 2009, Lyondell filed for bankruptcy. In July of 2009, the creditors committee filed a fraudulent conveyance lawsuit against Lyondell, its financing partners, claiming that Lyondell was insolvent because the stated value of its liabilities exceeded the fair value of its assets. Lyondell was insufficiently capitalized, and that bankruptcy was foreseeable. And the creditors committee sued Barclays individually as class representative of the Lyondell shareholders. There was a settlement that was reached with the LBO lenders in March of 2010. There was a plan of reorganization that was confirmed in April of 2010. And then the creditors committee removed the claim against the shareholder class, but there was created this creditor trust to bring state law avoidance actions. That case is still pending. In October of 2010 is when it was filed. Just catching up on the slides. And in December, the case was removed to the Southern District of New York, which is administering the case. There have been numerous motions to dismiss that were filed, and basically arguing 546E, just like in the Tribune matter. And those motions, I guess, were argued in May of 2011, and we're waiting for a decision on those. In terms of a couple of other recent developments before we turn it over for questions, just on May 29th, and this just relates to a different situation involving Hawker Beechcraft, which I know some of the folks on the phone may be interested in, which was a aircraft manufacturer that was involved in a 2007 buyout by Goldman Sachs and Onyx Partners. On May 29th of this year, the Pension Benefit Guarantee Corporation said that it wanted more time to conduct a full and complete investigation of the 2007 LBO, and what they claimed was the impetus for wanting to examine claims, fraudulent conveyance claims, was a decision in the TUSA case. And just briefly what that is and why it was significant is as follows. So TUSA, which is TOUSA Inc., was a home builder and developer that in 2005 had issued unsecured guarantees in connection with a leveraged joint venture. When the joint venture failed, the JV lenders sued TUSA as a guarantor, and to settle, TUSA agreed to pay money to the JV lenders on the guarantees. TUSA borrowed $500 million from its lenders to fund the settlement and pledged all of its subsidiaries' assets as collateral for the loan. The subsidiary pledgers were not defendants in the joint venture litigation, but the company's financing was such that the judgment in the litigation would trigger defaults and guarantor liability of the same subsidiaries. So what happens is, less than 6 months after the loan to fund the settlement, TUSA and its subsidiaries filed for Chapter 11, and the creditors committee commenced an adversary proceeding. The bankruptcy judge held a trial, and he found that the transfers were constructively fraudulent because there was no reasonably equivalent value. And the court ordered avoidance of the liens, disallowance of secured claims, disgorgement of principal interest, and expenses from the lenders. Went up to the district court. The district court reversed, and the district court said basically that the bankruptcy judge did things wrong. I'm shortcutting it. And then just recently, and the date of the 11th Circuit decision was, May 15 of 2012. And what the 11th Circuit said was that didn't find that the bankruptcy judge clearly erred in making his findings with respect to reasonably equivalent value. And what the bankruptcy judge, what the 11th Circuit basically said is that the question of reasonably equivalent value is a fact question and the bankruptcy judge was the fact finder, and it wasn't up to the district judge essentially to second guess the findings of the bankruptcy judge. So that's a recent decision that's being looked at by creditors, and obviously the PBGC feels emboldened by that decision, and I think we can see more of these fraudulent conveyance type claims being brought in the LBO context.
Just a word on this Hawker situation, which is interesting. There's always more going on in these cases than you just read in the decisions, right? So, so the PBGC and I'm not involved in Hawker, so I can talk about it. The PBGC in Hawker Beach doesn't want the company to shed its pension, doesn't want the company to terminate its pension plan because the PBGC is going to have it's substantially underfunded, and they'll have to pick up to the statutory limits the amount of the underfunding. And so, this case was supposed to be a pre-negotiated plan. It was all locked up. It was supposed to, they had a deal with the bondholders, and it was supposed to go through bankruptcy very quickly. The debtor is not going to bring the LBO action. It appears, just from press reports, I don't know if this is true or not, like there's at least a possibility that the creditors committee will decline to bring the action. So the PBGC uses the threat of seeking standing to bring a fraudulent transfer action to undo an LBO, right, to influence the debtor's thinking with respect to how it should treat its pension plan, right? So you don't have to, and if they do that, it's going to substantially delay this case that was supposed to be in and out of bankruptcy very quickly. And so the answer is sometimes you actually have to prove your case in order to win on the law and so forth. Sometimes that's all you have to do is make a credible sounding threat that you're going to stop a fast-moving train, and you may get some of what you want without ever having to test your legal theories.
Well, thank you. That it is an interesting case. It does have again a foreign dimension because Onyx, a Canadian entity, was one of the partners, sponsors of the LBO, and it's interesting because I guess they're trying to keep the bankruptcy alive rather than the pattern that you described where a creditor will rely on state claims outside of the bankruptcy. Instead, they want to ensure that the pension plans stay intact during the bankruptcy to allow this time for negotiation. So this trend of challenges to LBOs in different contexts is continuing, and it's affecting financial participants, individual shareholders, and others. It has really thrown the certainty of transactions into question as the case law develops and answers to some of the uncertainties become apparent.
Yeah, and there really have been efforts by creditors committee and other creditors to really be aggressive and bring claims that barely pass the straight face test in terms of, we're aware of one case where somebody who's a former note holder is being sued under fraudulent conveyance theory, which are difficult to believe, where somebody acquired their debt post-petition. So it's really difficult to believe what the claim might even be there.
So if people online, hopefully the chat tool is working, but assuming we're not having any technology glitches, please put your questions in. And are there any questions here in our live audience? Well, if not, we'll be around at the.
Yeah, and the other thing I'll note is our email addresses are on the screen for anyone on the phone that's unable to. If you have any questions, feel free to shoot us an email.
Absolutely, and we'll be here in person, but we'll also be watching our emails. So, thank you for coming in. Provided in connection with the transaction. So value is being extracted, perhaps by the shareholders who are actually tendering their shares and others, but the creditors down the road end up with having as an obligation obligations that are reduced in value because the company didn't receive adequate consideration or anything of reasonable value in return. And anyone who benefited in that manner in the transaction, in that artificial manner, could be potentially liable for the fraudulent transfer. So an LBO transactions are really prime targets for fraudulent conveyance claims because of the allocation of benefits, where some end up doing extremely well, and then when the company is found to be insolvent and eventually goes into bankruptcy, everyone is trying to find ways of reallocating the benefits that have been received over a period of time. These claims are obviously very difficult and expensive to litigate, and so settlements are possible. Some of the bigger cases that we're seeing now are of such a scope, and there's so many participants involved and so many claims to be potentially allocated and reallocated that it makes settlement potentially very difficult. Most of you are also familiar with the leverage buyout concept, where it's really the assets of the target company which are being used to finance an acquisition and a buyout, where the actual equity contribution by the sponsor of the LBO is relatively modest in relation to the overall capitalization being employed in relation to the LBO. In multi-step transactions involving a tender offer followed by a merger, public shareholders are also susceptible to having their proceeds recovered in these claims. So normally, the potential for fraudulent conveyance liability arises when there's an allegation that the debtor failed to receive adequate consideration for the transfer, and the debtor at the time of or as a result of the transfer was balance sheet insolvent, equitably insolvent, or left with unreasonably small capital. You can see that those tests are susceptible to a lot of interpretation, and we can talk about that. It's not, obviously, opinions are given at the time regarding fairness of transactions. None of the advisors believe at the time of the transaction that insolvency exists or is imminent. So you'll see that in the actual cases, there's a lot of thinking after the fact to look at what had occurred and how insolvency resulted and how inevitable it was as a result of the transaction. So in a way, on the face of it, when you first encounter claims like this, especially when they involve public shareholders, people who simply were investors or risk arbitrageurs who had no involvement in organizing the transaction, didn't act as advisors, had no inside information, but are still susceptible to these claims. And the legal theory really is that the other parties who were harmed don't have a seat at the table. So the unsecured creditors, in particular, have no way of participating in the LBO process in a way that's meaningful, that in the financial services industry for broker-dealers and investment advisors and also corporate finance transactions. A lot of my clients are foreign-based or foreign-affiliated, although they include domestic entities as well. So some of the principles we're talking about today could be even more surprising to a foreign bank, to a broker-dealer based in Europe or Canada or elsewhere, even though they can equally be surprising to a domestic audience. So after I speak, Michael Bernstein, who's at my far left, will be our next speaker, and he's the head of our national bankruptcy and insolvency practice. And he's based in Washington and has tremendous on-the-ground experience in dealing with the bankruptcy courts and dealing with the negotiations that arise from disputes such as this. Then after Michael, Stuart Aaron, who's immediately to my left, will be speaking. Stuart is the head of our New York office. Recently assumed that position. He's also the president of the New York County Lawyers Association. He's a securities litigator with tremendous experience in the financial services area, class action defense, and he's been taking the lead on a number of cases in the fraudulent conveyance area on behalf of our financial institution clients. So, most of you are familiar with the basic concept of fraudulent conveyances, that they're really designed to protect a company and its creditors from transactions that might cause harm where insufficient value is being provided. LBOs, if I go back to as far back to the 1980s and the Drexel Burnham days, they were a remarkable innovation because they really changed the market for corporate control in the United States, so that people with good ideas and with a plan for the business and who were able to perhaps revolutionize the company in some ways were able to participate in that marketplace and affect transactions that were impossible in the past. So they are LBOs, and there's a tremendous amount of financial literature associated with this, have, over time created tremendous value. But during periods when the credit markets have been roiled and a financial crisis has occurred and leverage is your enemy, many large-scale LBOs over the last few years have failed. And then these claims naturally come forward. So it's definitely kind of a mixed bag on the history of LBO since immediately before the financial crisis and through it, and it's going to create a lot of case law in this area. In fraudulent conveyance litigation, when the LBO fails, the parties they initiate litigation really with two primary purposes. The first is to really set aside the liens that have been granted to secured creditors in an effort to secure more value for the unsecured creditors on theories that we'll go into in more detail, but on the basis, again, that insufficient value has been conveyed and the transaction is viewed as a whole. In addition, would allow their interest to be protected. So that could provide kind of a theoretical justification for reallocating gains that are received by public shareholders because you have other parties that have been affected that didn't have a seat at the table. The other aspect of it is that you might even have claims brought by bodies like the Pension Benefit Guarantee Corporation, where they may very well, in cases, end up being one of the largest, if not the largest creditor. And if they can demonstrate fraudulent conveyance, they can protect U.S. taxpayers by avoiding the liability they would have to otherwise assume. So fraudulent conveyance law originally developed in response to situations where on the verge of insolvency, people basically secreted their assets or transferred them to others. And we're very far removed from the origins of it, where it was a transfer of assets to friends, relatives, leaving little or no value in their estates for creditors. And it was really, throughout the common law world, the fraudulent conveyance concept has developed along similar lines, even going back as far as 1570 in England. And the relevant phrase has always been, and continues actually to be in the law today, to some degree, to permit an attack on transfers made with the intent to delay, hinder, or defraud creditors. So that's the original purpose, and it's continued in this line to the present in these very large cases. So, obviously during the credit boom, many highly leveraged transactions occurred. People always